I'm Matt McFarland. I'm a staff attorney at the Tenderloin Housing Clinic. We represent many of the tenants who are here today. Steve Collier, my colleague, Raquel Fox over there, my colleague as well. We also represent one of the tenants whose landlord has joined in this lawsuit as a plaintiff. Her name is Stina Holman. She's been living in her apartment on Lombard Street for over 26 years. Her landlord has joined with a property rights group and some other landlords in order to try to overturn the Campos legislation. I'd first like to make a point to counter some of the propaganda that the landlords have been putting forward here in connection with this lawsuit. This is not the legislation that Supervisor Campos introduced, that the board and the city adopted. This is not a tax. This is not a taking of private property and shifting private property to a tenant. What this is a mitigation ordinance.
That's right.
The Ellis Act itself allows the city of San Francisco to mitigate the harsh effects of no-fault Ellis Act evictions. Supervisor Campos crafted and the city passed a mitigation ordinance that actually addresses a very real problem, which is that the old relocation money does not really mitigate anything. It doesn't get you anywhere in San Francisco's rental market. It doesn't get you anywhere if you've been an ideal tenant, but a speculator purchases your property and kicks you out through no fault of your own. This legislation actually does what the Ellis Act says the city can do, which is to mitigate the harsh impacts of an Ellis Act eviction. Another point that I think you definitely won't hear it from the landlord side and the speculator side is there's a hardship provision built into this law. If a landlord can't pay this money, there's a procedure in place for the landlord to bring a petition with the rent board in order to show that the relocation mitigation payment is too high. Guess what, folks? That's not happening. I'm aware of one landlord hardship petition. And you want to know why? Because the people that bring these Ellis Act evictions are perfectly capable of paying these mitigation payments. But if this kind of fictional landlord does exist, there is a provision in the ordinance, in the mitigation ordinance, for that landlord to bring a petition. Well, this is not happening, but let's not ignore the fact that the city and Supervisor Campos built this hardship into the ordinance itself. Third, I've read in connection with this case that there's this notion that if I have to pay this money, it's going to deplete all of my retirement savings. The ordinance also addresses that. If you bring a hardship petition, guess what money is not on the table? Retirement accounts. So I want to be very clear that this is not a tax. This is not a taking. This is not a transfer of wealth. This is a mitigation ordinance designed to address a very real problem. And I think personally that it does address that problem. It may be an imperfect solution to a very large problem, but it's a step in the right direction, and it's something that we need to fight for in order to keep it in place.
Yeah!